Hi there, I'm Steve Alsip with Rathbone Group, and this is an on-subrogation video about understanding the right to repair and right to cure laws in construction. Every construction project involves time, money, and trust. But what happens when things go wrong? This is where the right to repair and right to cure laws come into play. They're a crucial but often misunderstood aspect of construction law in the United States. So what is the right to cure? The right to cure allows construction companies a chance to fix defects before they face legal action. It's a statutory right available in 24 states, not available in 27 territories, including DC, which provides a buffer for contractors to remedy issues before there is litigation. In other words, the right to repair and right to cure frameworks temporarily protect the contractors from lawsuits filed by their clients until they've had the opportunity to inspect the defects and remedy any work that their clients may want to sue them over. Now, each state has its own set of rules for resolving disputes between homeowners and construction professionals. And this includes the architects, the designers, the contractors, and subcontractors, and any disputes that involve all of these parties. This can include contract disputes, tort claims, and breach of warranty. In addition to certain time limits ordinarily imposed on construction defect laws, certain states also have what's called the right to cure statute. These laws say that before filing a lawsuit, the project owner, such as the homeowner, must first notify the construction professional of the alleged defects and allow them the opportunity to repair the defect or pay for the problem. There are certain notice requirements that are necessary in bringing in these defective construction claims, however. First, before filing the lawsuit, homeowners must provide written notice to the contractor detailing the defects, usually allowing them 90 days to respond. The notice should describe the claim in sufficient detail and explain the nature and results of the defects, and include evidence in the form of photographs, videotapes, and any available expert reports that depict the nature of the construction defect. Now, when it comes to inspection and testing, contractors must be given 30 days to inspect the defects with options for non-destructive or even destructive testing if necessary. They must notify the homeowners in advance for any of these invasive tests. Within 30 days of receiving a contractor's request to inspect defects, the homeowner must provide the contractor and any of his agents with prompt, reasonable access to inspect and document all of the alleged defects. The contractor will then have 14 days after the inspection to either choose to repair the defects, offer a monetary settlement, or reject the claim. In cases where the contractor makes no response at all, silence, that is also considered a rejection of the claim. Otherwise, the response must be in writing. So what happens when the contractor refuses to repair the defect and refuses to make a monetary settlement? If the situation is that the contractor refuses to remedy the defect or settle the claim or fail to respond within that 30-day period, then the homeowner can bring the action against the contractor without any further notice. And it's important to note here that for any additional defects that are found after the initial notice, the process starts again for all of those defects. Basically, you send another notice for any other defect that you find. Understanding the right to repair and right to cure laws is crucial for both homeowners and construction professionals. It ensures the fair resolution of disputes while protecting everyone's rights. As subrogation professionals, it is important that these laws are understood in jurisdictions where they apply, because ultimately your right to recover damages may depend on whether or not those requirements were met. Join us again as we explore more legal insights and practical tips for navigating subrogation law in the United States. Don't forget to like, subscribe, and share on social media or wherever you're watching this video. And join us again soon on subrogation.